A very good afternoon, all. Welcome to this panel discussion, COVID-19 pandemic, managing the labor laws in India. The fundamental rights guaranteed in Part 3 of our Constitution and also the directive principles of the state policy, more particularly Article 38, 39, 42, 43, promise a just social order and strives to achieve social justice. One of the very important components of the social justice is the protection of the weaker section of the society. Now, if you have a look at the judicial precedent, the trend had been to protect this weaker section of the society and to afford the workers constitutionally and legally guaranteed rights, and thereby creating a wonderful edifice for the protection of the workers' right and maintaining the dignity of the labor. Now, if we look at this trend, with the passage of this time, this protection, this constitutionally guaranteed protection of the labor rights are threatened with the onset of the liberalization of the economy. And free market economy has been considered to be the only way out for the growth of the economy of our country. And this thought has largely surfaced in the policies of the legislature, in the executive, and also in the approach of the judiciary. Now, this COVID-19 outbreak has put an ignition to this expansion of this liberal thought towards these labor regulatory measures. And as a result of which, what we have come across, number of states have either withdrawn or diluted or suspended some of the very important labor legislations. The states are of this opinion that this could be one effective mode of reviving the economy of our country. We understand that our country needs a reform, a major reform. We also understand that a reform in the labor regulatory measure could be attributed to this reform. But the question of the hour is, do we actually need this kind of measures which would be at the cost of the basic fundamental right and dignity of the laborer? So this is this question, and with this question, I'm Dr. Prasenjit Kundu, Assistant Professor of Law, Dr. Lohiya National Law University. Welcome you all to this panel discussion, COVID-19 pandemic, managing the labor laws in India. I'm delighted to have extreme speakers in our panel who would be speaking on this issue, that is COVID-19 pandemic and managing the labor laws in India. So to start with, Mr. Ravi Shankar Jha. We are glad to have with us Mr. Ravi Shankar Jha. He's a lawyer and a policy analyst. After having worked as a corporate lawyer for close to years, thereafter he pursued his post-graduation in public policy from National University of Singapore. He currently works as a senior investment specialist with Invest India, Ministry of Commerce and Industry, Government of India. On behalf of Dr. Manohar National Law University and also on my own behalf, I extend my cordial welcome to Ravi Shankar Jha. We are very fortunate to have with us Dr. Uday Shankar, Associate Professor, IIT Kharagpur, a renowned academician and a prolific writer. Dr. Uday Shankar is presently working as an Associate Professor of Law at Rajiv Gandhi School of Intellectual Property Law, Indian Institute of Technology, Kharagpur. With his extensive research in constitutional law, socioeconomic rights, energy law, and more importantly, in the area of labor and industrial law, Dr. Uday Shankar has made his contribution in more than 10 books which are published by different reputed publishers. On behalf of Dr. Lohiya National Law University and also on my own behalf, I extend my cordial welcome to you, sir. We are extremely fortunate to have with us Dr. R.K. Murali, Professor, Banaras Hindu University, Faculty of Law. Being a professor of professors, Dr. R.K. Murali sir actually does not need any introduction. A very well-known professor in the legal academia, and he keeps his audience speechless with his magnificent way of insightful deliberation on legal issues. We remain grateful to his immense contribution in the area of labor law, jurisprudence, human rights, IPR, and also in the Code of Criminal Procedure. Let me take this privilege to welcome sir. On behalf of Dr. Lohiya National Law University and also on my own behalf, I extend my cordial welcome to you, sir. So now let's go into this discussion, that is COVID-19 pandemic, managing the labor laws in India. So we're going to start with Ravi Shankar Jha. So he can set the tone of this discussion. Ravi, we have a very specific question to you, and we would like to hear your opinion on this thing. See, if we have a look at the labor jurisprudence, we know like there are two distinct periods of this labor jurisprudence. In the initial stage, we see that protection of these socio-democratic rights of the laborers, and thereafter we see the dilution of these rights. Uh, that dilution is evident in the approach of the judiciary, in the measures of the legislature and the executive, everywhere, in every organ of the state. Now, I have one of your articles in my hand. It got just published in the Economic Times, and you wrote something that why Indian economy needs swift and robust labor reforms, right? So from that article, what I could gather that you are looking for massive changes in the labor reforms and in the labor policy. As a measure of that reform, what you are suggesting and what you have also supported, that the dilution of these labor laws or the suspension of the labor laws by states, you actually have welcomed this step, right? So my specific question to you is, like, why do you think that this dilution of the labor law can be a viable measure for bringing that changes in the labor jurisprudence? Why do you think that this is a very important measure, and this could be a very crucial measure for as a labor regulatory measure? So, what is your opinion on it?
All right. Since I mean, it's a very important question, and it requires us to go probably beyond the simplest, beyond the questions of law itself. And so I'll take a little more time in explaining why I wrote what I wrote. So the economic model which has been proposed during our modern times, and that is irrespective of whether you believe. Okay, yeah, so that is irrespective of whether you believe in a capitalist economy or you believe in a socialist economy or a completely communist economy. Irrespective of the kind of economy that you believe in, the model of economic growth is pretty much the same. We start as being an agriculture-based society. From there, as the population grows, because of certain inherent limitations that agriculture has in terms of the number of people that it can absorb, you necessarily move to manufacturing, because that is where the jobs can be created en masse. And then as you mature as an economy, you transform into services sector, where of course limited number of people do extremely high value addition to the economy. Now, this is the economic model which has been practiced. They're largely successful. There are many countries which have failed, but then it continues to be a model which is accepted across the board, and it is agnostic to the economic philosophy that you subscribe to, which I mentioned, communist, socialist, or capitalist. Therefore, it becomes necessary, and so that is the model. Now, in India, We have agriculture, which has stagnated completely for reasons, of course, that requires its own analysis. But the problem is that it contributes 17% to our economy, but employs 55% of our labor force. That is just not sustainable for several reasons. One very basic reason could be that as we move further in terms of future generation, the land will continue to get fragmented, and that leads to its own problems. India has had a unique experience where it never really became a mature manufacturing economy. We directly jumped to services sector, but that has not been a complete solution. We need manufacturing to absorb a huge labor force that we have. Now, what we did with these kind of legislations, we focused on protecting jobs. And there are some startling numbers that I can quote. And as I just said, that the major chunk of our labor is in agriculture, rest is in informal sector. Through these labor laws, which we claim supposedly protects the lawyer, you are merely protecting around 3% of our country's labor force. Now, the reason why I am, and the 97% continue to remain unprotected. And the reason why they remain unprotected is precisely, again, I can explain it later during our conversation, that these labor laws have become an impediment for people who want to set their manufacturing industries here. And that this is not to mean that this is the only problem. We can talk about economics 101, which is land, labor, and capital, 3 factors of production. And India has problems on all these fronts, but labor is one of those fronts, and it has created problems for people. It's general common sense. If you told me that, Ravi, come and participate in this discussion. However, once you come in, I'll not let you go. Or I will not let you go for 3 days. I will not come. That's the simple, I mean, I'm making it very simplistic, but that's the argument. The point is, and this is just one Industrial Dispute Act 5B, where you have now made it impossible for people that once you absorb someone, you can't fire them. And this flies completely in the face of normal business logic, which goes through cycles, crests and troughs. And you must allow that flexibility to entrepreneurs to have that thing, so that if their business goes down, they should be allowed to either at least cut salaries or change the nature of the jobs their laborers are supposed to be employed in, or in worst case scenario, to fire them. By not creating, by taking away this fundamental right, so to say, you have completely discouraged industries to come and set their shops. I think I'll close it there for now. And as we proceed further, I'll give you evidences to support all the claims that I've made. Hello.
Ravi, we can hear you. Yes.
Yeah, I think I'll rest my case there for now. I'll give, as we proceed further, I'll give evidences for all the claims that I have made.
Okay. Yeah, Ravi, we have one more question for you, because you are thinking about this application of the labor law in a liberal way, and you also talk about that liberalization of the Indian economy, etc., etc. So we see, like, when we look at the Indian market economy, that expansion of that Indian market economy, we require that higher rule or free market economy, etc. So could you please brief us, like, what do you understand by this free market economy? If you could give us some examples of the free market economy, and why do you think that revival of the Indian economy, we need to have this free market economy concept, which needs to be brought, and that to at the cost of the labor rights and the dignity of the labor, etc., etc. So if you could highlight this issue regarding this free market economy and its impact on the revival of the Indian economy, and also some examples of countries where you have come across that free market economy has been very successful in reviving the economy of that particular country.
Yes. To put it very simplistically, free market economy entails minimal government intervention. Contrary to what people think, it is not that government is just not there. what free market economy entails is that government should be present in as minimalistic way as possible. Now, just to give you an example, there are several mom and pop shops that you see keep cropping up in our hinterland, even in big cities. Someone just brings up a thela and puts some cigarettes and some chocolates and toffees and opens his shop. Now, this is a very simple example of a free market economy where if I want to start a business, I don't need to be running from pillar to post to get permissions that, okay, is this the place where I can set my thela, or is that the place where I can set my thela, or whether I can start this business. If once the government starts doing all this, it gradually erodes into what is called the concept of free market economy. And this flows directly from our whole idea of libertarian thought that we so much advocate for in our political and social life. What essentially the argument of a liberal thought process is that government should be no one to be telling me what am I supposed to wear, where I'm supposed to go, what I'm supposed to do with my life. If you extend the same logic to the economic field, that's exactly what the free market economy tells you. Government should not tell me what I should do, what kind of enterprise I should open, how much should I sell, what I should sell, what I should not sell. That's the idea of free market economy. Now, there have been some champions, yes. Now, having said that, you always have some sort of regulations for different purposes. Let's say if I open a restaurant, there definitely should be regulations to ensure that my food that I'm serving to people has certain basic minimum hygiene standards. Second could be something as simple as someone who is looking to set up a pawn shop should inform the government so that government has data of people who are employed in different kind of business. These are different kind of small minimalistic regulations which no one says should not be there. However, government should not come and tell me you cannot be selling more than 10 cigarette packs a day, for example. That is intervention. That you are impeding in free market economy. Now, there was a beautiful example which I read when I was reading this book many, many years ago called India Unbound. And I would probably like to quote from it to kind of bring out the difference. Now, in this book, Gurcharan Das quotes one person called Prakash Tandon who wrote a classic memoir called Punjabi Century. And he narrates his story. He says each year he used to take his family on holiday to Kashmir by road from Bombay. One year, he noticed the petrol station had come up on the highway beyond Nasik. About the same time, a large public sector factory had also come up 20 kilometers beyond the petrol pump. Competing with, and this factory was complete with tree-lined boulevards, spacious homes, schools, hospitals, and sport amenities. Next year, this person noticed that the petrol pump was doing good business and a mechanic shop had come up alongside. The following year, he found that a roadside restaurant had also come up. Its food was especially popular among truck drivers. A cigarette and pan vendor also followed, then a fruit seller. Next came a tailor and a general merchant. In less than a decade, a flourishing little town emerged. Meanwhile, the state company began to lose money, and in the same period, its losses had grown colossal. Now, this contrast is instructive. In one case, wealth was created organically. A lonely petrol pump attracted entrepreneurs and they offered services that people wanted. They reinvested their profits and they expanded. Their profit in turn attracted others. In the end, it was society's wealth was generated from within and it supported a flourishing population of 1,000 families. It all started with a small petrol pump. While 20 kilometers away, we created a factory which the government thought is necessary because they thought this is what the country needs. And gradually it started incurring losses. So that is the contrast of a government intervened economy, whereas when you allow free spirit of market to come and create ecosystems where people have jobs and the economy flourishes. Some of the classic examples, of course, the champion of it is United States, Western Europe, which use free market economy, and they sit at the top of the economic pile today and are leaders of global economy. China changed its track from being a communist and a socialist economy, even though it continues to have some labor rights on paper. its growth, phenomenal growth through the last 3 decades, has been premised on easy acquisition of land and very, very flexible labor legislation.
Thank you, Ravi. Now we move on to Dr. Uday Shankar, sir. Uh, we have been talking about this, revival of the Indian economy and the measures which need to be taken up for reforming the labor sector, etc., etc. So we are sure, like, as you have been putting huge work on this field, so we are sure, like, you must be having some ideas that what strategies to be, adopted so that we can make a balance. Because we agree, like, we need a reform in our country, and that reform must incorporate some reforms in the labor sector as well. So if you could kindly highlight the strategies which need to be adopted, whether it should be left from the state or the center should play its major role in regulating the labor market. So what is your plan? What is your idea? Like, if you could highlight on this issue, sir.
Yeah, thanks, Prasenjit, and it's pleasure participating in this panel discussion with two eminent speakers. Yeah, this pandemic has exposed many shortcomings of the governance. It has exposed the vulnerability of the working class. It has also exposed the promises made under the labor laws. It has, also brought in to the surface multi-layered fallacies in the system. And in that, it appears that the working class is the most worst sufferer. Now, when you look at the crisis at hand, there is an important message which this crisis is sending across. And the message is that it is a time to look towards the provinces, the state governments. In fact, what we are observing that the workers are returning back to their native states, and the states are also responding by bringing in changes in the existing labor laws. Now, to me, it appears to be a case of fundamental change to be done the way we have been dealing with the issues of employment, labor, and the issue of dispute resolution. Now, when you look at the changes which have been made, which largely conveys in the direction of creating job market, which is driven by the idea of having more investment so that employment opportunity get generated. When you look at the changes which are being made, some of the states, they have diluted the Factories Act. They have increased the number of working hours in the factory. They have postponed the applicability of good number of labor laws for good 1,000 days. In fact, I would say the beginning has happened when the lockdown was announced and the government of India has issued an instruction that every worker shall be paid wages. Now, the matter is certainly contested one. It has gone to the Code of Law, and the Supreme Court has observed that employers should not be coerced. They should not be compelled to make the payment. And obviously, it appears that when you look at the language of the law, it is very difficult to say with all certainty that there is all legality in the instruction. To me, the government would have referred to the language of sustainable allowance, the government should have referred to the language of advance payment instead of making it a payment of wages, which is purely governed under a law, and you compel the employer to remit the salaries when the workers have not worked, firstly, and secondly when the corporates are also under stress. It's not that corporates are not under stress. So somehow there are complexities involved in this direction. So there are changes made. The changes uh, are made by more than one states. In fact, UP has suggested, I mean, UP has gone to the extent of diluting good number of labor laws. And as I have been told by the moderator of the session, Professor Kundu, that it has withdrawn now. Gujarat has made the changes. MP has made the changes. And when you look at the changes which are being made, it is primarily on working hours. It is primarily on giving the more space to the employer with regard to deciding on the terms and condition. And because of that, good provisions of Industrial Disputes Act have been also relaxed. Now the question is, when states are coming forward and revisiting labor laws, what is needed is to look at the very challenge which is there before the state, and how this challenge can get addressed for a better future for the working class, and which is more sustainable in nature. Now, for last 70 years, we have been witnessing a kind of top-bottom model where center comes up with the laws on important issues, and states, they do implement. They have a responsibility to implement the central laws, and wherever it is desirable, the state comes up with its own amendment, obviously where the approval is required from the central. But then, even with all these suggestions which the state is making, there is sort of apprehension. The apprehension is that the suggestions which are being made by the states, they are diluting the labor rights. And statistics says that even though we have a very relatively cheap labor when you compare with China, but we do not have enough employment opportunity in manufacturing sector, as it was said by Mr. Ravi. So where we are heading for with this kind of suggestions? Because when you look at the reforms, it doesn't appear to be a very structural one. It more appears to be a kind of cosmetic changes, or a kind of hurried response to the situation which has emerged during this pandemic. Now, there are certain critical features which we know about labor laws in this country. They are marred with, you may say, self-contradictory kind of perceptions. On the one hand, we say that labor laws are very rigid. On the other hand, when you look at the position of labor laws, when you look at the wages, wages which are being paid to the laborers in this country, they do not get adequate, protection. So there are kind of self-contradiction. There are kind of conflict which is there. So labor laws appears to be a kind of more effective on paper than on the ground. Multiplicity of laws is another important problem. Then over-regulation also is an issue which certainly affects the inefficiency. Then what you look at is that when you look at the kind of conditionalities which are being connected on, which are being said with regard to safety of workers, health of workers, again you find there that some archaic provisions are still there in the labor laws. And then you have official and unofficial exemption under the labor laws, which in a way encourages the employers to look for the way to evade the labor laws. Now, when you look at the constitutional scheme, and there where I am basing my argument, which primarily suggests on bottom-top approach and more power to the state. When I was reading the assembly debates, I come across with an observation which was made by Pandit Thakur Das, who was a member of the Constituent Assembly, and he made a very pertinent point. He said that the industry should be decentralized as much the administration should also be decentralized, meaning thereby that when you're talking about regulating the industry, regulating the labor matter, let the state be more empowered. And something on the similar line suggested by another member of the Constituent Assembly, that is Kaka Bhagwat Roy. He also made a very important point while discussing on having this industry as a subject matter in the 7th schedule of the Constitution. He said, as far as industry as a subject matter is concerned, it can be effectively addressed when the state has a kind of regulating power over it, because Kaka Bhagwat Roy made this point that every province should should be given facilities to solve its own problem. So in a way, there were indications where it was said that let the regulation come from the state. And can we say that what we are witnessing now is a sort of showing us a new path for having set of labor laws which would truly serve the labor class? Because when you look at the of the center and the state, some considerable number of subject is there in the concurrent list. Employment is in the concurrent list. Trade union is in the concurrent list. Labor is in the concurrent list. Now, the point is that when they are in the concurrent list, we generally look at it more from a centralized perspective. That because it is in the central list, because it is in the concurrent list, there is a possibility where we look at like center must have a prime role to play. But then the concurrent list, the idea behind the concurrent list is not all about giving primacy to the center. It's all about the coordination and cooperation between the center and the state. And in fact, Sarkaria Commission, NCRWC, Punchi Commission, all these commissions which have been given the task to revisit center-state relations, they have categorically mentioned about it. In the concurrent list does not mean that states shall be given a kind of states shall be completely ignored in the making of the laws. And perhaps that's what we are finding that happening with the labor laws, because center makes a law and then the state, as we know that administrative machinery is under the control of the state, and the state has a responsibility to implement laws. And some of the states have some of the states, they do propose a kind of amendment in the laws which are made by center, but at the same time somewhere it appears that the reform which has been suggested by the state appears to be a sort of kind of piecemeal approach instead of looking at the issues in a comprehensive way. So when you look at the positioning of the state, it appears that the important subject matters which are very core to ensure dignity to this working class, for example collective bargaining, for example social dialogue, for example dispute resolution, issues of contract labor, because contract labor is now a reality. And even though we have a central law, but it is a matter of fact that majority of the states have not come up with any kind of list to abolish it. So, and then the issue of trade union. Now, these important laws, if you allow the state to structure it as per the need of the state, because culture plays a very important role. Culture plays an important role in resolving the dispute. Culture plays important role, in forming a kind of, association. And you have an example at hand. I mean, if you refer the Minimum Wages Act, wherein state advisory board has been given enough power to decide on the slab, considering the living condition, considering the category of industry. So there are instances where if you empower the state, then it appears that the state has been doing the needful to protect the interest. India is an heterogeneous society. I mean, it is very difficult to have a kind of a model one size fit all. You must now time is very ripe. This pandemic is an opportunity for all the states, that instead of one government thinking about welfare of the working class, let 27 governments think about welfare of the working class, and let every chief minister be accountable to it. And that's what this whole crisis on migrant worker is, kind of a wake up call for all of us. So I would say that this is an opportune time to revisit our model and how we should look at the issues of labor laws, and why states should be states should be made more accountable, and states should be made more empowered. It will ensure transparency. It will ensure kind of transparency in decision making process. It will make the state more accountable. That's what I thought of giving my preliminary thought on this issue. And certainly I'll be speaking more once we get a kind of opinion from the audience as well as other speakers. Thank you, Prasenjit.
Thank you very much, sir, for enlightening us on this issue. We will again get back to you. Now we move to Professor R.K. Murali, sir. Sir, can you hear? Sir, can you hear me?
I can hear you.
Yeah.
Are you able to hear me?
Sir, there is some disturbance in your sound. Hello.
I do not know precisely what is the disturbance.
Yeah, sir, now it's fine. So the point which we want to raise before you, that we have been dealing with labor law, sir. And I personally have raised so many judgments. Like, if I can refer you Central Inland Water Transport Corporation versus Brojanath Ganguly, I really remember an observation of the court that any kind of condition in your service matter, in your contract of employment, which gives insecurity in the mind of the workers, is against the public good as well as against the public policy, and can be hit under Section 23 of the Indian Contract Act. So this was a jurisprudence we have been observing, the socio-democratic protection of the workers' right. It's not only Central Inland Water Transport Corporation. We know there have been thousands of cases where the court had shown this kind of creative attitude for protecting the weaker section of the society. So this is at one hand, but at the same time, right now we see this dilution. We see this suspension of the labor laws to a huge extent. So if you could put some light on this issue, like what kind of protection is actually required to be afforded to the workers? What do we understand by the workers' interest? How their interest can be protected, even into taking into consideration the major reforms in the labor sector. So if you could highlight some of the important things of the protection of the labor rights by giving due recognition to the socio-democratic rights of the workers. So we would be highly obliged if you could please, put some light on this issue. Thank you, sir.
Yeah, thank you. Let me begin now. See, I would just like to start my lecture with a very important observation that when you talk about the importance of labor laws, we obviously say that human rights are more important than property rights. And like my previous speaker was referring to a very liberal economy. So I was reminded of a particular book, a very sensational book written by Robert Nozick, State, Anarchy and Utopia, wherein he goes to the extent of saying that the property rights, they trump the duties of benevolence. No, when property rights, of course, are in the ascendancy after 1991, particularly in India. See, after 1991 in India, we of course switched to a new economic policy. We have a new industrial policy, but what of course is lacking is a new labor policy. And then when I talk about the importance of labor laws, and particularly on the advent of this COVID crisis, now I would like to impress upon the people of this country that labor laws, of course, they are so important to the workers that they become so integral to their very existence. And Chapter 5B of the Industrial Disputes Act, which is projected to be a draconian legislation, wherein the employers who want to retrench, lay off, or close their industrial establishments, which of course is a factory, mine, or a plantation, which employs 100 or more than 100 workers. And in 1976, there was a very drastic departure from the basic scheme of the Industrial Disputes Act, wherein the employers who run factories, mine, or plantations, employing 100 or more than 100 workmen, they were asked to take the permission from the government before they actually can lay off or retrench or closure or close the industrial establishments. Immediately, the employers of this country, they thought that it's a draconian legislature. It is interfering with the fundamental rights. So they immediately went to the Supreme Court and challenged this particular Chapter 5B as a draconian law. And that, of course, it is a legislation which protects the employment of the workers. And it, of course, is giving more importance to directive principles of state policy. Now, we all know that any particular law which is made in pursuance of directive principles of state policy, though it might be inconsistent with fundamental rights, it will be declared as constitutional. Now, what I'm trying to stress here is a very important and very fundamental point. See, after 1991, let us put the issue straight. It is income security versus job security. It is rehabilitation versus liquidation. And it is fundamental rights versus directive principles of state policy. And it is investment versus disinvestment. After 1991, for example, I want to tell you a very important judgment given by Justice Ramaswamy, in which he said the two parallel streams of thinking. One is the expansion of the meaning of state under Article 12 of the Indian Constitution, and the other is the expansive interpretation given to the definition of industry under the Industrial Disputes Act. They, of course, have given over protection to the workers in this particular country. But what ails the public sector? Now, why are we saying that out of 238 public sector undertakings, 58 have become chronically sick? Now, what is the way out? When we, of course, in public sector are chronically sick, some of the most important undertakings in the public sector, they are chronically sick. What is the way out? Now, here what I want to emphasize is, the government thought, let us go for disinvestment after 1991. Let us now come to the Balco case. Now, in the Balco case, Bharat Aluminium Company case, which of course was a disinvestment case. Now, please, I'm not taking any sides here. First of all, you listen to me patiently, and then, of course, I will come to some very important conclusions. In the Balco's case, the workers argued before the Supreme Court that when Balco is privatized, when the government disinvests the shares, when the government goes back, their fundamental rights under Article 14 or 16 will be affected. And that is very important because so long as Balco continues to be a public sector undertaking, they can enjoy the fundamental rights under Article 14 or 16, which gives them security of job. And that is, of course, very important in the absence of social security. In a country like India, where there is no social security mechanism in the proper sense of it, job security is the only security. And the Supreme Court in the Balco's case, it said that what economic policies the government makes, that is beyond tutorial intervention. Supreme Court said we do not have the wisdom to question the economic policies of the government. After 1991, of course, you switched to a market-oriented economic policy. And three important revolutions are responsible for the birth of the labor law. One is the industrial revolution, the other is the capitalist revolution, and the third and the most important is the free market economy. So these, of course, are important for the very genesis of the labor law because capitalism requires labor law for its survival. Capitalism requires, they did not start labor law because they have the law for workers. It is for their own survival they started this labor law. That is the reformist movement. And so far the revolution movement advocated by Karl Marx is concerned, that will dismantle capitalism and establish socialism. But then in India, we went for a reformist agenda. Within the capitalist system, we want to have labor law to ensure that the workers at least are given certain basic rights. Now, so far as Balco's case is concerned, Supreme Court said that workers do not have a vested right in the fundamental rights. And the fundamental rights can be divested by a change in the economic policy. So that is a very important observation, particularly after 1991, because the phase of globalization now. Now, what I am trying to tell you here is that before 1991, of course, we followed a particular labor law which was more in favor of workers. Workers' interests were protected. But after 1991, though, of course, there is no change in the law so far as the statutes are concerned. But in practice, the labor laws are more ignored today. They are more violated. For example, I can tell you many important things. So Chapter 5B of the Industrial Disputes Act, it is the most controversial area. People say that it has, of course, given job security? No, let me tell you one very important thing. Let us go to Excelways case. Excelways versus Union of India. Now, in Excelways case, Supreme Court explained the meaning of socialism in a mixed economy. Now, see, this is very important for the present discussion. What exactly is socialism in a mixed economy like India, where there is also private sector with the public sector? The private sector is also playing a very important role in economic activities in India. Now, Supreme Court said that Supreme Court distinguishes between two types of socialism. One is doctrinal socialism and the other one is rationalistic socialism. One is rational, the other is pragmatic socialism. Now, what is doctrinal socialism? For example, doctrinal socialism will support socialism just for the sake of a principle. It will say socialism is always good, irrespective of the consequences. The consequences may be bad, but socialism is always good. That's an a priori consideration. But so far as the pragmatic socialism is concerned, that is what the Supreme Court was in favor of. Supreme Court said that pragmatic socialism is concerned about socialism with its efficiency, whether the socialism that is being implemented in India is giving results or not. It is not a doctrinal approach. It is something which is a pragmatic approach, wherein we want to ensure that the economic policies of the country are really effective. And so a pragmatist and doctrinal considerations, this Supreme Court explained very clearly. And Supreme Court in that particular case said that the industry will be run for redeeming economic objectives. Industry cannot be run only for the sake of running the industry just to protect the employment. For example, Supreme Court also said that how can you compel private employers in this country to run the industry when they are not in a position to run the industry anymore? What is the use of running the industry without any redeeming economic objectives? Can you ask the employers in this country to run the industry even at the cost of their life and property? Can you ask the employers to continue to run the industry even if they face losses continuously? No, these are the very important questions raised by the Supreme Court in the Excelways case, which of course have shown a path towards not a doctrinal socialism, but a pragmatic socialism, wherein of course we are concerned about the efficiency of our economic policies. Don't run the industries only to protect the employment. We of course want to protect the employment, but that is not the only issue. There are so many other issues. So Supreme Court of course has very rightly stated in the particular Excelways case that when we talk about socialism in a mixed economy like India, wherein there are private players, the Supreme Court said that the private players, the private limited companies, they run the industries. Majority of the industries are being run by private limited companies. And there are a number of persons who, of course, like shareholders, creditors, depositors. Now, all these people are also equally very important. Now, you cannot always say only workers are important. And you cannot always say workers' security is the job security is the only paramount important consideration. Now, Supreme Court is saying that when we have a private sector and when we have so many other players in the field, then obviously socialism must be understood in accordance with the private aspects of employment also, the private entrepreneurs. So they should be given some breathing space. So finally, Supreme Court in that particular case, it declared the Section 25O as unconstitutional because it thought that the Section 25O is doctrinal in its approach. And the government can refuse to give you permission to close the undertaking, though of course you are in financial losses. And though you are incurring losses year after year. So what is the way out? A pragmatic solution. Now let me come to certain very important things. You asked me very fundamental questions. See, when we talk about the Industrial Disputes Act, Trade Unions Act, Industrial Employment Standing Orders Act. Now under the Industrial Disputes Act, we have a tripartite method of solving the industrial disputes. Now tripartite means what? For example, in the Industrial Disputes Act, you have the Labor Court. You have the Industrial Tribunal, which is a third party. They will adjudicate the industrial dispute and give the award. That means the third party is giving an award, which is binding on the parties. So under the Industrial Disputes Act, the state is the custodian of industrial peace and harmony. The entire labor law under the Industrial Disputes Act is under the control of the government. When we come to Trade Unions Act, the Trade Unions Act is based on the American model. Industrial Disputes Act is based on the Soviet model. Industrial Disputes Act believes in state intervention. And the government plays a very important role in the Industrial Disputes Act, and the entire labor law under the Industrial Disputes Act is under the control of the government. And now I would like to remind my audience here that when President Obama came to India, a very important question was asked to him. So why Americans are so good economically? Why it is such an economically powerful country? Now what is the answer given by him? He said third party is always a suspect. So what do you mean by third party? Let the government not come in between the labor and management. Government is the third party. government comes between the labor and management in India in the Industrial Disputes Act and plays politics. So they say that let the employers and the workers decide their industrial disputes. Let not the government come in between. And so they believe in bipartite collective bargaining in America. In India, of course, we also believe in bipartite collective bargaining, that is in the Trade Unions Act. But so far the trade unions are concerned, they should be given certain privileges so as to ensure that they become equal to the employers. So under the Trade Unions Act, we of course have given many important privileges to trade unions so as to enable them to bargain effectively with the employers. But let me make a very important point here, observation. What is the observation? In India, deliberately we did not develop the Trade Unions Act vis-a-vis the Industrial Disputes Act. We give more importance to Industrial Disputes Act because we believe in state intervention. And we want that the entire labor law must be under the control of the state. And we believe that in a planned economy like ours, the state, of course, must regulate your right to go on strikes and lockouts. Now, I will tell you a very important thing. In India, we believe that adjudication is more important than strikes and lockouts. And we say that war is too important to be left in the hands of generals. That means war is too important. Strikes and lockouts are so important that they should not be under the control of employers and workmen. Workers must not decide when they should go on strike. It is the state that should decide by regulating the right to go on strike. So in India, the right to strike is not a fundamental right because the workers are given the fundamental right to go on strike that would affect the planned economy. So we, of course, have a labor law, which, of course, is Trade Unions Act, Bipartite, Industrial Disputes Act, Tripartite, Industrial Employment Standing Orders Act. And finally, I come to the most important thing. We have a plethora of minimum standards legislation, like Minimum Wages Act, like Payment of Wages Act, Payment of Bonus Act, Provident Fund Act, Gratuity Act, like 150 labor laws are there. Now, let me tell you, when we talk about the plethora of these minimum standards legislation, these are not matters of collective bargaining in India. Minimum wage is not a subject matter of collective bargaining in India. It is a matter of statutory law. So the law says in India that the employers must pay the minimum wages and the capacity of the employer to pay is irrelevant. Whether he can pay the minimum wages or not, whether he has the capacity or not, that is irrelevant. He has to pay the minimum wages even though he may be running in losses. That is the law. So when employers approached the Supreme Court and they wanted that the Minimum Wages Act should be declared as unconstitutional on the ground that it is a violation of Article 19(1)(g) of the Indian Constitution, the Supreme Court said that now there is a conflict of interest. On one side it is Article 19(1)(g). On the other side, the workers cannot survive even if they are not given the minimum wages. So we go to a sociological school of jurisprudence, and now an exercise in absolute is illusory. Now, you cannot take a stand that labor law must be pro-workers. No, you cannot give absolute answers. Now, the answer is what? You must try to reconcile the conflicting interests. The Supreme Court in this particular case said that minimum wages law is constitutional. Why? Because if the worker is not given the minimum wages at all, then he cannot eat. And if he cannot eat, he will become sick. And if he becomes sick, he cannot contribute for the development of the country. You require a healthy worker to contribute for the economic development of the country. So employers' right to carry on business and the workers' right to get minimum wages, the Supreme Court said between these two conflicting interests at this particular point of time, in this particular facts and circumstances, the workers' right to receive minimum wages is more important than the employer's right to carry on business or trade under Article 19(1)(g). But that is only minimum wage. There are standards of wages, fair wage, living wage. Under Article 43 of the Indian Constitution, living wage is the constitutional goal. But that is something to be achieved in future. And that, of course, is a matter of industrial dispute. But if the employer does not give you minimum wages, you don't have to raise an industrial dispute for that. You directly can go to the complaining, make a complaint that the employer did not give you minimum wages. You can show the law and get it enforced. So what I'm trying to tell you is that in India, we have plethora of legislations, and these legislations have taken these minimum wages, minimum bonus, minimum provident fund out of the hands of the trade unions. So trade unions, they are not that important in India. And the government did not deliberately develop the trade union because it wanted that the entire labor law must be under the control of the state. And that is, of course, what is happening in India today. Now, let me come to a very important point because now the latest observations. Now, what we see in India after 1991. After 1991, when we look at the definition of retrenchment in Section 200 of the Industrial Disputes Act, today we're talking about voluntary retirement schemes. Now, voluntary retirement scheme, why? Because the existing labor law is very rigid. The existing is protecting the workers' interests. So the employers, they cannot close the industry without taking permission from the government. The employers, of course, retrain the workers. Chapter 5A of the Industrial Disputes Act, they have to give compensation to the workers. So the workers, of course, are protected in this particular country. So what is important is that now people are resorting to what they are doing in practice is different from what is in the statute. Now, voluntary retirement schemes. So these voluntary retirement schemes, how voluntary they are. How voluntary are these voluntary retirement schemes? I do not know. But Supreme Court in number of judgments said that there is no distinction between a retirement under voluntary retirement and voluntary retirement scheme. Now, voluntary retirement scheme is put on par with voluntary retirement. So what I mean to emphasize here is that when we talk about the new labor laws that of course are prevailing in prevalence in the country, these labor laws, they are not in the statute, but they are in practice. What is that? Employers are ignoring with impunity the standards of their labor, the minimum standards, and the government is not prosecuting them. Well, because the government itself is interested to ensure that these labor laws are not that important, and the government does not have the courage to bring about a change in the labor laws directly. So what you cannot do directly, particularly when you look at the Contract Labor Regulation Abolition Act, and when you look at the Uma Devi's case. Then Uma Devi's case is a very important judgment, wherein the Supreme Court said the government is not filling up regular vacancies in the country. Though there are millions and millions of vacancies in the country, government is not giving regular vacancies. And the government is only taking up part-time workers, temporary workers, ad hoc workers, casual workers. And this is the way the government is running the industries today. And when these casual workers, when these ad hoc workers, they went to the Supreme Court and said, sir, we have put in 15 years of service. Now we should be made regular. What is the answer given by the Supreme Court, Constitutional Bench in the Uma Devi's case? The Supreme Court said that, of course, you have put in 15 years of service, but you cannot be made a regular worker. Why cannot be? Because you did not face the regular interview. Unless you face the regular interview, unless you go through the screening process correctly, which is a legalized one, you cannot be given a regular employee status. So what I mean to tell you is that after 1991, we see an increase in the casual laborers, in the ad hoc workers. Why? Because the government itself is... Yeah, you can have ask me questions, but then what is important for me to just see? Contract, one more important thing. Contract Labor Regulation Abolition Act. Today, contract labor has become the order of the day, despite the law which says that it is applicable to factories and establishments employing 20 or more than 20 workers. But then regulation and abolition. Regulation, of course, is very important. The very genesis of the Contract Labor Act is because of Standard Vacuum Companies case. That is 1960 judgment. 1970, we have the Contract Labor Act. And the Contract Labor Act, of course, it has regularized the service conditions of the contract laborers by ensuring that they get minimum wages, they get minimum facilities. Okay, these are good. Abolition. Abolition, government can also abolish the employment of contract labor under Section 10 of the Contract Labor Act under certain guidelines which are provided by the legislature. Now, the question before the Supreme Court was, when the contract labor system is abolished, what will happen to those workers working under the contractor? In one judgment, Justice Ramaswamy said that when the contract labor system is abolished, the workers working under the contractor, they will become regular workmen. But that judgment was immediately overruled by another judgment of the Supreme Court, which said that the workers working under the contractor, they will also go. They will not become regular just because the contract labor system is abolished. So what I mean to tell you here is that, see, there are so many issues here. Contract Labor Regulation Abolition Act, that of course is fundamentally a particular law that deals with the contract labor. And today, we believe in informal employment. 92% of the workers are in the unorganized sector. And last but not the least, before I wind up, I want to tell you certain very important things. Today, people say that formalization. The formalization or formalism in the labor law in India is because our labor laws are very rigid. So they say it should be made flexible. And once it is made flexible, they believe that it will become that the informal people will also come into the formal sector. But let me tell you that just because you make the labor law flexible, it is not going to attract any capital investment. Just because you reduce the number of hours of work in factories like Yogi Adityanath has done in Uttar Pradesh, suspending all the labor laws, with the belief that the suspension of labor law, even the Minimum Wages Act, to my surprise, my God, Minimum Wages Act is also suspended. Factory legislation which stipulates the minimum decency, minimum human condition, particularly the maternity leave for women employees and the occupational and safety hazards. And these are very important. And the Factories Act makes a very important contribution towards the health, safety and welfare of the workers. And even these laws are suspended in Uttar Pradesh. And whether a regulatory chaos has been created in Uttar Pradesh. Now, what I mean to say is cholesterol, regulatory cholesterol that should be removed. Okay, you can amend some labor laws, but you cannot say all the labor laws will be drastically changed or they'll be suspended because of the COVID crisis. No, I don't agree with that. I believe that humanitarian consideration is very important, and the private sector cannot abdicate its responsibility by saying that no, let the government pay the minimum wages. We, of course, are in the private sector. But I will tell you one thing: the paradoxical thing is that, like the Supreme Court said in Escort's case, in India, the private people do private business with public money. They borrow money from the banks, so they cannot just wash off their hands and they cannot just say that we are not socially accountable. Now, what is the importance of BIFR? Now, why did BIFR come in India? Because the Supreme Court in Excelway's case said that if the private employers are unable to run the industry, let the government take it over. Why should the government take it over? So we went for BIFR, Sikh Industrial Companies Act. So what I mean to tell you is that labor laws are important. Let us not write the obituary of labor law. Of course, we want capital investment. We want more generation of job employment. We want many things. But the solution is not to suspend the labor laws. The solution is to respect the labor rights and strike a balance between the competing interests, but not an exercise in absolutes. Thank you.
Kundu sir, you are on mute.
Right now. Okay, I am finished now. If you want to ask me any questions.
Okay. No, sir. Can you hear me now?
Yeah.
Yes.
Yeah. Sir, I was just thanking you for your brilliant lecture. You have enlightened us like anything. So we have questions, and in fact, we have questions for all the speakers. Let's start with R.K. Murali sir. Sir, you have been talking about this private enterprises and their obligation to pay the salary, etc., etc. You referred a judgment also, right? That the private players, these private enterprises, they are making money out of public. So that is what they have a responsibility to give the salary to the employees. Sir, let me draw your attention. Sir, on 20th of March 2020, if you can hear me properly, sir, on 20th of March 2020, the Ministry of Labour and Employment, Government of India, has issued a letter to all the employers association to circulate advisory to all employers and owners of all the establishments that employers of private and public establishments not to terminate and reduce the wages of the employees. This is what is the circular which been issued from the ministry. But you know, and we all know, like there have been thousands of cases in different sectors where we see that the employer has cut the salary, has terminated the services of the employees during this outbreak of the pandemic. In the context, like they in fact do not have any means to survive, and that is what they cannot continue with this many number of employees. So, sir, the question is like, what would be the remedy in that case? If supposedly an employer has terminated the services of an employee during this phase of time, or there is a pay cut. So, what would be the remedy for that employee or for that worker under this situation? So, if you could please highlight on this issue.
Yeah, see, the law is very clear. The law is very clear. As far as this retrenchment after closure or whatever it is concerned, even the private employees are under the constitutional scrutiny. The Constitution gives the workers certain basic rights. And what is important for me to describe at this point is that when the worker services are terminated, they have a remedy under the Industrial Disputes Act. Because Chapter 5A of the Industrial Disputes Act is there. Chapter 5B of the Industrial Disputes Act is there. And let me tell you one thing, sir. You asked me a very important question. The question was that these labor laws are not implemented in practice. Now, 8% of the workers in India are in the organized sector. And they say workers in the organized sector are overprotected. And in the unorganized sector, there is no labor law at all. So they can be very easily exploited. But the paradoxical thing is that even the 8% of labor laws which are applicable in the organized sector, they are very poorly implemented. The implementation aspect is very poor. And so we can say that our labor laws are already flexible, though ostensibly they appear to be rigid, but they're already flexible. Flexible because in the enforcement, we don't give importance to enforce strictly what is written in the statute, and we violate with impunity. And that is the order of the day in India. So when these workers in the private sector employment, when they are not given minimum wages, the only solution is that make it enforceable. The law is there, but the practice and the law, they are not matching with each other. The practice is something different. Oh, yeah, you can ask me.
Yeah, sir. But this basic question coming from so many participants. One is saying he's not in a position because that production has come to the standstill. So how come
Yeah.
he can compare? Because he's saying my production has come to the standstill altogether. So from
Yeah.
where I'll meet up these expenses, and I'm compelled to terminate the services number of the employees. So what is my fault, and what kind of he's just asking like where is my fault? Like can
Okay,
we?
okay, okay. I understood the importance of the question. Let me tell you that when in 1991 we introduced economic reforms, sir, my audience, when Prime Minister Narasimha went to America, when he invested American investors to come and invest in India, they said they will not come and invest in India. Your labor laws are a big impediment for economic development. And your particular Chapter 5B, you don't have an exit policy. What is an exit policy? You can start an industry in India, but you cannot make an exit. Because if you want to make an exit, you have to take permission from the government. And like the Supreme Court also said, what is the use of compelling the employer to run the industry when without any redeeming economic objectives? Industry cannot be run only for the sake of running the industry to protect the employment. You should have some economic objectives. Now, what is your question? Private employers are not in a position to pay minimum wages. So why should they be compelled to pay minimum wages? No, my answer is that private employers, of course, they see so far as minimum wages are concerned, sir, capacity to pay is irrelevant. These are the minimum standards, and we have a way out. If you are not in a position to pay minimum wages, the only option for you is to close the industry. You cannot run the industry when you are not in a position to pay minimum wages. That is what the Supreme Court said in the accelerated case and number of judgments. So what is important is that the private employers in this country, they cannot shirk away from their responsibilities, and they cannot just say that we are not in capacity to discharge these socio-economic obligations. Now, these socio-economic obligations are very important, and I do feel that very important research has to be conducted, because like there was a very important research, and that research has revealed many important things. They say, the private employers say they are sick. Actually, they are not sick. They are very healthy, but they project themselves to be sick. So their audits must be accounted, and their accounts must be audited properly, and you must see whether they are really sick, because they project as though they are sick, and financially they are sound. It is like East India Company. The company has become bankrupt, but the shareholders have retained millions. So what is important is that let us not jump to conclusions. Let us not say that the private employers must be given a free hand because they are not in a position to discharge these minimum socio-economic obligations. They must discharge. They are socially accountable, and it cannot be decided in a general way. No, each case has to be understood according to its own merits. And if the employer is really financially not in a position to pay, then of course that employer can be exempted. But you cannot make a sweeping declaration that private employers, because of the financial and other problems. So these, of course, any employer can give these excuses. So we have to understand that the society plays a very important role in development of private economy. And my father's money and your father's money, which is in the bank, they take money from the banks as loans at a very subsidized rate of interest. Tata and Birla, they bring only 1 rupee. Remaining 99 rupees they borrow from the bank. So they are socially accountable. So they cannot escape by saying that we are not socially accountable. Only the government is accountable for the socio-economic obligation, and we private people, we should be exempted from all the socio-economic obligations. I never agree with that. I believe that the private employers, the private people in the country, they equally have a duty towards the society, not only the government. Thank you.
Thank you very much, sir. The next question which we have is for Ravi Shankar Jha. The question is, what could be the ramifications of the suspension of 35 out of 38 labor laws for 3 years by UP, which is approved by UP temporary exemption from certain labor laws ordinance 2020. So essentially, what is the question? Like we know like this has been taken back by the state of UP, but if you could apply it to any other state, what would be the ramification of taking back 35 legislations out of 38 legislations in a particular state? What do you think? Do you think that this is a progressive state to revive the market? So if you could please put some light on this issue.
Yeah, that's now that is a very, very difficult and complex question. Now, I will not kind of go so far as saying that removal of all these laws is appropriate and nothing should be done to kind of provide minimal sort of protection to the labor. However, having said that, with that statement, I'll say that what we have focused so far in our discussion and what gets a lot of attention in our discussion on issues of labor law and how it affects the economy is Industrial Disputes Act, Chapter 5B. Now, that is not the whole story. The story is that you have 55 central legislation and more than 100, in total around 150, 160 labor law legislations with different terms. You can find 15 different definition of the word worker itself within the within different statutes. Now, what it does, now these are things for which we don't have answers in law. We have to go and refer to economics. Each regulation that the government enforces in any sector whatsoever increases the cost of compliance. Now, in an economy which is so globally integrated, where you are competing with jurisdictions like Thailand, Malaysia, Vietnam in your neighborhood, and of course other producers across the globe, where in a day and age where you have free trade agreements with free flow of goods, you are competing with different producers in different countries who are not burdened by such cost of compliance. And just to give you an idea about how much the cost of compliance is, there is a very, very detailed and interesting study by, let me quote the name of the authors. The paper is called Indian Labor Regulations and Cost of Corruption Evidence from the First Size Distribution. Amrit Amreparu and Michael Getcher. This paper estimated that the cost could be as high as 35%. Now, just to give you a sense of what that means, which industries survive can actually be determined by a cost differential of 1%. If you are disadvantaged to the extent of, now these are mathematical study, they could be off by 5% here and there. But if you are burdening your industries with additional costs of 15, 20, 25%, and that too in an environment where you have 150 different legislation. Now, let me give you an example. There are certain wage laws where minimum wages have been decided as, let me give you a very, very quick example. Wages in some sector would be, just a second. Yeah. So, as per Minimum Wages Act, a laundry and washing clothes laborer in Tamil Nadu is entitled to 346 rupees 0.20 paise. Is that the level of regulation that you want to get into to determine, how much money, like how many paise will you be paying to your labor? And this is just one example. There are several such examples. This is the myriad of legislation that you have created, which puts additional burden on the industry and increases the cost. And this is just one factor of production we are talking about. We know how difficult it is in this country to acquire land, which pushes up your cost further. So you are making your industries now, when we reach out to people to come and invest in India, they tell us, forget about the export. Now we can assume that Indian market is probably big enough. But the fact is, if we come to India, we start producing, there are goods coming from abroad as well, Vietnam, Thailand, Malaysia, who don't have to bear these costs. Those goods will be cheaper. Your very same people will not buy those goods because my goods will be more expensive. So you add the cost. And just to give you an example on this, might not be a very sensitive example, but let me be very blunt. And this is my personal view. Republic of Singapore got independence in 1965, 18 years after India got independent. It has no minimum wage law. Not a single labor from Singapore migrates to India to find work, whereas thousands of Indians migrate to Singapore since decades now to find jobs. Does minimum wage really provide protection, or are you taking away the rights of people? Now, my idea is stop patronizing the labor. Give them the freedom. You might have some pain for 10 years, 15 years, but you will see gradually there will be 50 different industries. And if one industry refuses to pay a certain amount, there will be a competitor who will say, come and work with me, I'll pay you higher wage. That is the trade-off that we are dealing with. And that is very, very critical. Now, I would also like to take exception to one of the issues that was raised to say, I mean, I don't deny that every corporation has social responsibility, definitely. But the fact that they take money from public, that's the whole banking business. Public gives money in the bank because they expect certain interest. That interest is generated by the business that entrepreneurs create. So it's not that by giving them money, the banks or public are doing some charity. They are giving them money because they believe that this entrepreneur has the ability to multiply the money. And out of 100 loans that you give, 10, 15 go back, 80 others come back, and therefore you get interest. So that in itself cannot be a ground to impose social responsibility on corporates. So that inside, but coming back to the first point that I was trying to make, 35, 38 different legislations are not going to work. Workers should have minimal human conditions to work. Probably we can even consider having minimum wage in Indian context. I don't mind. But there has to be visibility, clarity on labor law legislations and compliances. They should ideally be kept to the minimum to make your own industry competitive. If you don't do that, in the long run, what you will eventually see that all these industries, something that we saw happen in front of our eyes with Kanpur, complete deindustrialization. That is what we will see, and 25, 30 years down the line, we will not have a single industry working here. Also addressing, now this is again my personal view, one can take exception to such sweeping removal of labor laws, but there are larger considerations at stake. We are witnessing a kind of international movement where companies are scampering to get out of China. Who are you competing with? You're competing with Vietnam, Thailand again. Vietnam gives you a land in a day, literally in a day or maximum a week. It takes you 2 years to provide land to the industry.
Okay,
now,
Ravi, a very live question. A very live question has come before us that you're talking about Singapore. So have you seen how COVID-19 has affected foreign laborers in Singapore?
Yes.
How their lives are. So he wants us to comment on this issue because you have been talking about scenario and etc.
I'll do that. I'll do that. But let me complete this line, which I was the point that I was trying to make. That these things, unless you send a message out to the world that India is ready to bite the bullet, to take up difficult reforms, because in 1991 we did not do any supply side reforms. In 1991, theoretically, what we did, we said, okay, you produce what you want, but everything that goes into the process of production, be it land, labor, mineral, continued to be within the control of the government. So, and that is the most difficult reform. So to send out that message, such a step was probably necessary. In fact, even today, 3 years is not a good enough period. It takes 5 years to set up an industry. And someone comes, sets up an industry, and then 3 years later, you say, no, I'll apply every law. In fact, it can actually backfire. So therefore, probably a lot more thinking that needs to go into it. And then finally, the question of migrant labor. The point is that these are not directly related. This is a condition where best of countries with finest of infrastructure are struggling. Singapore, all said and done, has had a sudden spike in number of cases in the dormitories where they house the laborers, but they are being able to control it because of the resources that they have had, precisely because they have had favorable industrial policy. And in fact, now there is a debate going on that they would provide better working conditions, better places to house those laborers in coming years. Singapore is able to do that because it has the resources. We unfortunately can't do it.
Okay, thank you, Ravi. We have a few questions for Dr. Uday Shankar. The first question that participant wants to ask you, that you talked about that suspension of the labor laws and etc. And this strategy which need to be adopted by the state, etc. His simple question is like, this suspension of the laws will leave the workers to use the method of strikes as the only option. Won't it create more problem during this phase when the economy is already delicate? So what he is essentially trying to ask, like during this phase of COVID-19, outbreak of COVID-19, when you're talking about the suspension of the labor laws, so if the workers now go for a strike and etc., won't it create more problem to this, looking into this delicacy of this problem? So he wants your comment on this issue.
Okay, so Looking at the whole issue during COVID-19, see, we are addressing to whom? If they are workers uh, having a legal right under the labor laws, they should have, asserted their position wherever they were working. Why they are returning back to their native states? That itself takes the very grounding of the rights what we are talking about. Moreover, now again building upon the argument which I was taking, that when you talk about the conflict resolution, we generally read that conflict resolution has three aspects or three different dimensions. One is you resolve the conflict through power. The other is you resolve the conflict through rights, and third one is you resolve the conflict through interest. Now, when you resolve the conflict through power, it has its own disadvantage. When you resolve the conflict through rights, obviously one party always carries the kind of grudge against the system that my right has not been rightly read. But when you make an attempt to when you make an attempt to resolve the conflict through the interest perspective, then certainly there is a possibility of win-win situation. Now, labor relation, industrial relation is one such area where conflict should certainly get resolved, considering the interest fact, where we must have a kind of win-win situation for both the parties. And that's what I'm highlighting at, that when you look at the decentralization, the benefit of decentralization, if you allow the state to be more empowered on structuring labor laws, on designing the thresholds, then there is a larger possibility where his interest can be resolved in amicable manner, because the very fact that only 8 to 9% of the workforce is getting benefited, that itself is a good testimony of the whole uh, understanding of the labor laws. I mean, that's what the argument I'm saying, that to whom we are talking about. If our discussion is only for 8%, then obviously we have a sufficient legal mechanism in place. But then I believe this COVID-19 has exposed that any talk on labor laws should not be only for this 8 to 9% of the workforce. It must be for all who matters for the growth of the nation. Now, the point is, as it was been mentioned by the panelists, that resource scarce is there. Yes, it is there. I mean, there is a kind of uh, hardship on every stakeholder. But then the question comes in, that why it should be shared only by the workers. If there is economic hardship, then obviously this must be shared equitably amongst all. And when the government is announcing the package, there is a responsibility of the industry to come forward and to hold the hand of the workers. And at the same time, the worker must also not put up a demand which is unrealistic in this present situation.
Okay, thank you very much, sir. We have a lot of questions, but due to the paucity of the time, we cannot raise all the questions to be addressed. I am taking up a question which I will be putting in front of all of you. All of you, please quickly answer this question. How do you strike a balance? Like reform, you need some reform in the labor regulatory measures. At the same time, you need to protect the interests of the weaker section of the society. So keeping these two things in your mind, the suspension of the labor laws or the dilution of the labor rights, which been initiated by the state government, but the different state government. So how do you look at this step which has been taken by the government? Very quickly, we start with Ravi.
Sorry?
Did you follow my question?
No.
Okay, just very quickly you answer this question, that there are two extreme points. One is the protection of the labor rights, their security, their healthy way of living, etc., etc. At the same time, we have this dilution of the labor rights in of this pandemic, and different measures have been taken up by the state, right? So wow, what is your final take on the different initiatives taken by the state in this regard? Very quickly, 1 and 2 minutes.
Yes, I think these initiatives are well long due, and I'm glad the states have taken it up. Probably there will be some back and forth on this issue, and governments will kind of try and accommodate some of the reasonable demands that comes from labor community, and rightly so. However, the larger direction in which the reform is moving is absolutely necessary, and it will help us at least improve on one count of factor of production, which is labor, and hopefully will attract industries. And what we'll see going in future, going forward, that with these laws out of the place, there will be more formalization of labor. More labor will be absorbed into the industry, and not only this small percentage of 7 to 8% or even 3%, so far, according to some studies, more will be attracted. They will have greater options to choose who their employer is going forward. Yes, that's
Okay,
what
thank you, Ravi. We now move to Uday Shankar sir. Sir, what is your final take on this issue?
Yeah, ultimately, see, the responsibility of delivering public good is largely with the state government. I
Yes.
would say suspension is not an answer to this question. What is the need of the hour is to restructure the labor laws so that what working class has been missing all along, they must be given their due, and for which the any piecemeal solution is not something what is warranted. What is required is a kind of comprehensive restructuring, and perhaps COVID-19 has given us very good opportunity to deliberate and come up with a robust system for the larger welfare of the working class.
Thank you, sir. We move to now Professor R.K. Murali, sir. Sir, what will take on this issue, that dilution of the labor laws, and where do you find that solution? Because we really need some reform in the labor regulatory measures. So how do you make a balance between these two extreme points?
Sir, my illustrious speakers who preceded me, of course, their conclusions are good. Adam Smith is the father of economic liberalism. I understand that one particular speaker is supporting Adam Smith, who is the father of modern economics, and then supporting a liberalized environment in India. And he thinks that this liberalized environment, of course, will pave the way. It is the path for a better future. But my own understanding is that, sir, market economy, state must intervene in the market. I don't go for a complete pure market economy model, because there are imperfections in the market in India, and the state must of course play a role. And when we talk about suspending the entire labor laws for a period of 3 years, a moratorium for 3 years, no, 3 years period, of course, I agree with one of my speakers, is too less a period. But my answer would be that even suspending the minimum wages laws and minimum factory legislations, which give you health, safety, basic things. What happened in Visakhapatnam, we already know that, how the gas leaked. And we have, of course, witnessed a number of things we don't take proper care. So what they mean to ensure is the minimum thing. Why Minimum Wages Act is passed? Because the workers' bargaining power is poor, and left to their own selves, they cannot get minimum wages. So the legislature made the Minimum Wages Act just to protect those workers in the unorganized sector who cannot protect their own interests. That is very important, and that continues to be a reality today. So let us not be very emotional in saying that let us dispense even with the minimum wages laws. Now, these laws are very important. They are the very basic fabric of a socio-economic pattern of economy, particularly in a country like India. And now I believe that it will be boomeranging on us. It will be counterproductive if we suspend the entire labor laws. Now, I do agree that some labor laws must be changed. They require a change. Workers in the organized sector, they are overprotected. Of course, we should go for some income security also, because we cannot give job security in the 21st century. Of course, we should believe in certain income security also. We have to, of course, go towards certain new direction. But it doesn't mean that we suspend the entire thing and we go for entirely a different policy event, a drastic departure from the existing one. The departure must be slow. The departure must be gradual. The departure must not be overnight, because like David Hume, one of the philosophers, said, change is welcome, but sudden change is always dangerous. So let us believe that, let us change the labor law gradually and ensure that the workers, of course, are protected. At the same time, the economy also develops. So it is not only economic development, it is equally economic justice. Economic justice and economic development, they are two sides of the same coin. So you cannot only talk about development at the cost of exploitation of the workers. Thank you.
Thank you very much, sir. So we have had all sort of discussions on this issue, like the protection of the labor rights, the direction of the labor rights, the market reforms, the labor market reforms, the revival of the market economy. And with this, we come to the end of this panel discussion. And it's been a really great pleasure and honor to get these, distinguished speakers as panelists. On behalf of Lohiya family and also on my behalf, I extend my sincere thanks to all the panelists. And I also extend my appreciation to all the participants for their kind support. I'm definitely looking forward to your kind cooperation in near future as well. Wish all of you virus-free, happy, healthy stay at your home. Thank you very much.
Thank you, sir. Thank you.
Thank you.